Muito bom dia para todas e todos. Sejam bem-vindas e bem-vindos à nossa FMP, a Fundação Escola Superior do Ministério Público, para uma atividade relacionada à nossa Escola de Direito, ao nosso programa de pós-graduação em Direito, aqui da nossa FMP. Hoje nós temos uma reunião do grupo de pesquisa que eu, Francisco Mota, professor aqui da casa, coordeno, o grupo de pesquisa denominado Teoria do Direito da Academia à Prática. E hoje nós temos uma atividade muito especial para todos nós. Como todos sabem antecipadamente, hoje nós vamos ter a oportunidade de conversar com o professor Gerald Postema, um dos pesquisadores mais importantes desse campo de pesquisa por qualquer régua que se meça. Então, eu vou falar rapidamente como a nossa atividade vai funcionar. As atividades do grupo de pesquisa nesse semestre foram coancoradas pelo amigo, colega Gilberto Morbach. Eu vou apresentá-lo na sequência, ele vai dividir essa atividade comigo, vai comigo receber o professor Postema. O professor Postema vai fazer, eu vou fazer uma pequena exposição aí em inglês, depois a nossa atividade vai ser em inglês. Vou fazer então essa breve apresentação do autor, uma breve apresentação do Gilberto. Nós vamos passar a palavra ao professor Postema para a sua conferência. E a partir daí, Gilberto e eu temos as questões, enfim, para discutir com ele, para debater com ele. Se a assistência também tiver perguntas, fique à vontade para mandar. Na medida do possível, o Gilberto e eu vamos filtrar e vamos incluir isso na atividade com o professor Postema, e a nossa atividade tem uma duração máxima de até 2 horas, então até o meio-dia nós encerraremos. Certo? Então, let me open our talk today, which is entitled Laws, Rule, and Law as Artificial Reason. And for our talk today, the event will be co-hosted by me and Gilberto Morbach. And we will both receive here today Professor Gerald Postema. As a matter of fact, Professor Postema needs absolutely no introduction whatsoever, but in any case, he's Professor Emeritus of Philosophy at the University of North Carolina at Chapel Hill, Doctor Honoris Causa, University of Athens. He's a Fellow of Corpus Christi College, Cambridge, a Guggenheim Fellow, a Rockefeller Fellow, Bellagio, and a Fellow of the Netherlands Institute for Advanced Studies. He has held visiting posts at the University of Cambridge, the European University Institute in Florence, the University of Athens, Yale University, and University of California, Berkeley. So, Professor Postema, thank you so very much for taking the time to talk to us. Please notice, as we have discussed before, that we absolutely do not take for granted the opportunity to be alongside one of the leading scholars of the globe when it comes to legal theory and legal philosophy by any available metric. So let me open with a brief introduction. Professor, as we have discussed before, I coordinate a research group here at FMP, which is currently dealing with legal and constitutional theory. To be more specific, we have been dealing since the second semester of 2024 with legality and rule of law, issues that led us to engage more recently with your latest work. So we have read the following as a group since the beginning of 2025. We have read Law's Rule, the nature, value, and viability of the rule of law, Law as Artificial Reason 1, Law's Discipline, Law as Artificial Reason 2, Common Reasoning, Conflict, and Congruence, and finally, Analogical Reasoning, in law, creativity, constraint, and jurisprudence. As you can imagine, on the one hand, all these readings have deeply increased our repertoire for thinking about law as a distinctive practice and about the rule of law per se. But on the other hand, we now have a bucket full of issues and questions that we would like to discuss with you later on. So we really cherish the opportunity to hear it directly from you today and maybe to address you some questions about this afterwards. So, Professor, with renewed thanks from us, you can please have the floor now.
It is an enormous pleasure to be with you here or there or both places. I would rather, of course, it'll be even more of a pleasure for me to be there with you directly, but this is a very appropriate and delightful second best. It is always a great pleasure for me to return to Brazil. I've been many times. I've been hosted graciously by your colleagues, and I'm glad to be back again to speak with you. I'm also honored that you spent time looking at some of my work. Um, One writes in a study, but hopes that someone will look at it after you're finished. Is very gratifying. So, shall I just begin now with my
By all
talk,
means,
or
professor.
did Professor Morbach have something to say?
Se o Gilberto puder aparecer para fazer as suas. Gilberto, for your initial remarks.
No, Professor, I think you're more than welcome to start. It's really, like Francisco said, I second everything he said. It's a great honor. It's a great pleasure for us to have you here again with us. You'll always be at home here in Brazil, so you can have the floor, please. Like we said, as the rock star that you are, please.
Well, thank you very much. Let me begin then. Um, I have lately succumbed to a certain illness called retrospectionitis. Perhaps you haven't heard of it, but it's a well documented illness to which aging scholars are especially vulnerable. Um, it's the irresistible tendency to look back over and dwell on one's work over the years. However, I'd like to um, imagine this activity in slightly different terms. I imagine my early career, say 30-year-old self, looking through the window of my study. I wonder what themes, what through lines of thought or argument I would find. How does it add up? I thought I would give you a report from my view through the window. So I call this talk Philosophical Jurisprudence, A View Through the Window. So, upon my first glance, what appears is that my main focus throughout this career has been not exclusively, but very much dominantly on philosophical jurisprudence, broadly construed. I have written and taught on various figures in the history of philosophy, especially Hume and Hegel, but my main work is focused on law, legal practice, from three different perspectives, actually. One from legal theory, what some call analytic legal philosophy, concerned with the nature of law and legal reasoning. So I've talked about topics like law as a social practice, the nature of public reason, the nature of conventions or social norms, laws, time, mindfulness, and the like. Um, Also, I looked at it from a moral political theory perspective, uh, giving attention to professional ethics, to ideas of justice and integrity, equality, membership, and even covenant. Um, but also, I've looked at this enterprise through the eyes of history, the history of legal theory in particular. First, I worked on Bentham, and then on classical common law jurisprudence, especially the work of Sir Matthew Hale. But I also have interacted with, throughout the years, Plato and Aristotle, of course, medieval Arab, Jewish, and Christian philosophers, including Al-Farabi and Maimonides and Aquinas and even Marsilius of Padua, and certain modern thinkers like Grotius and one of my favorites, but you don't know him, Johannes Althusius. And lately, I've been focusing on Anglo-American legal theory in the 20th century, of course. So my 30-year-old self says, wow, that covers quite a range. Do you have a problem keeping your intellectual focus, hey, Postuma? Or is there something that connects these various topics other than your peculiar intellectual whim of the moment? So my 30-year-old self sees a possible answer that seems to have emerged rather later in my biography. I began to articulate a certain conception or understanding of the aims and methods of legal philosophy, an articulation of the approach to this enterprise that apparently had been in some way implicit all along. So I called it then jurisprudence as a sociable science, or more pretentiously, jurisprudence as vera philosophia. By sociable, of course, I mean not social as a social science as opposed to, say, physical science, but a sociable as opposed to isolated and set apart, but rather engaged with other approaches to understanding law. So, what is jurisprudence as a sociable science? Well, it conceives of the endeavor as neither purely abstract and theoretical, nor strictly practical or policy oriented, but rather the point at which theoretical and practical intersect, the point where analytical and historical inquiry, universal and the local, intersect. It's sociable then in the sense that it seeks and depends on a partnership with other modes of inquiry into the law, all the while being fundamentally philosophical and, as I will argue, hence constitutionally critical. I'll return to this model of philosophical jurisprudence later in the talk, but first, though, I thought I would illustrate its operation in my work over the years. First, from history to theory. It's clear that my historical work, first on Bentham, and then through his criticism of it to 17th century common law jurisprudence and Matthew Hale, this work, historical work, bent my, at the same time, analytical and theoretical work in the direction of seeing law not as a set or even a system of rules, but as a kind of social practice, and especially in the direction of common law idea of law as artificial reason. Deep work in the 17th century English jurisprudence of mine, aided by more general reflections on the emergence of modern jurisprudential thinking, led me to appreciate the fruitfulness of thinking of law as, in the jargon I use, thinking of law as a disciplined practice of public reasoning. In a number of works written over the years, I've tried systematically to articulate and defend this conception of law's nature. In time, a practical, moral, political concern of mine also took my attention. This is a concern about the nature and viability of the rule of law. The image of law as artificial reason enabled me to articulate a coherent approach to this important ideal. Actually, the story of the emergence of common law conception, law as an artificial reason, suggested an important perspective on the widely embraced but just as widely contested ideal of the rule of law. The very term artificial reason and the rich conception of law it denoted emerged from a contest between 17th century common law judges, Edward Hooke and Sir Matthew Hale in particular, and the English kings of the time, especially James I. Like modern rules, notably Donald Trump, James sought for the legitimacy of the cover of law while wriggling out of its constraints. In effect, he said to Cook, it's said that law is reason. Well, I'm capable of reason, in fact, supremely so. So I can judge whatever is legal and what is not on my own. I don't need courts to tell me. I can exercise legal authority as I judge it. James tried to set himself up as the sole judge of the legitimacy of his actions according to law. In effect, he claimed La loi c'est moi, or at least I'm the reason of law. Sounds familiar, doesn't it? Cook and Hale responded, nope, no, while you, sir, have an admirable capacity for natural reason, the reason of law is artificial. It's acquired through apprenticeship in a specific discipline, through study and habituation in the practice of law. In this way, the reason of law is special or specific, just like the reason of the mathematician or the physician. Thus, and this is crucial, your judgment of the legality of your actions is always subject to the assessment by those who, as a community, exercise this special reason. Thus, the historical importance of the common law conception of law lay in politics. In the contest between James I and common law judges was not simply an abstract or theoretical one, but rather it was an intense, high-stakes contest. One lesson we can draw from this is law is not merely a tool of rulers, but a technology that tempers ruling power, one that offers a structure for public accountability of ruling power. This represents a challenge, of course, to, at that time and throughout a good bit of history, to a dominant conception of law, most powerfully perhaps articulated by Thomas Hobbes, but it's implicit in jurisprudential work for a long time. Namely, that law is command, the product of lawmaking activity of those who hold and exercise ruling power. Against this image, common lawyers developed a conception of law that did not depend on the creation or articulation of rules by a sovereign, but rather could operate as technology by which sovereign ruling power could be constrained. Laws could stand in judgment on ruling power. Law could itself be sovereign. Thus, the image of law as artificial reason was forged in the crucible of a struggle over ruling power, if you will, a struggle for the rule of law. This really immediately raises new questions. How can law bridle ruling power? What is it about law that equips it for this task? Also, wherein lies its vaunted value? Why think that the realization of the rule of law, even when imperfect, is some important achievement? Is it valued just because it's useful, a relatively efficient means of achieving the aim of the rule of law? Or does it, in addition, have features that commend it to us? These questions throw us back onto the enterprise of systematic reflection on the nature of law, and to systematic thinking about the value of law with respect to other important moral and political values. Now we have a framework provided by the image of law as artificial reason. What could that mean? How does thinking of law in these terms deepen our understanding of our experience of law and its role in law's human, social, and political context? So here for a few minutes, I'm going to just kind of give an overview of this idea of law as artificial reason. Since many of you have looked at recent work of mine on this, you should find it familiar. I just thought it would be useful to have it available for our mutual reference. So we begin our reflection on the nature of law from this perspective, not with the aim of serving the ideal of the rule of law, but rather from certain bedrock observations about law itself. Observations that the image of artificial reason may be able to help us articulate. So one of these, first, bedrock observations. Social fact. Law is a social fact, a social phenomenon of a kind that doesn't automatically win our favor. law is not necessarily good or just or even reasonable. Recall John Austin's slogan, "The existence of law is one thing, its merit or demerit is another." And yet, it is a social fact that has a certain kind of normative significance. This is apparent from another bedrock thought. As we say in colloquial terms, might isn't right, or right stands against might. The sheer exercise of power over others, whether or not it's legitimate, is, we assume, deeply opposed to law, to the way law works. Moreover, when people who are subject to law have, with good reason, regard themselves as victims who can only view what claims to be law as nothing more than other people's power, when this happens, the law has failed in some fundamental way, failed not just to be good or even just, but failed as law. Law, it appears, has or claims a certain normative character. It does this work not by goading, but by guiding, not by causing behavior, but by providing reasons for behavior, not by manipulating the conditions of their actions, by addressing the capabilities of rational agents for practical deliberation. You might sum this up by saying that law's distinctive modus operandi is to offer normative guidance to those who are subject to it, regarded as rational moral agents. The image of law as artificial reason offers a way of honoring and articulating these bedrock thoughts, offering a route to a deeper understanding of the nature of law. Here, let me summarize briefly key features of this conception of law. Artificial reason, first of all. Reason, I'll break this up, reason and then artificial. Reason, rather than power or command, but not reason with capital letters as some kind of transcendent model of the universe, but rather reason as a mode of reasoning. Laws are the product of such reasoning, or rather, various nodes in a complex network or array of interrelated reasons. Laws get their meaning as laws, that is, their content and their practical force, through their participation in this network. This place is uncovered by rationally capable subjects engaging in this mode of reasoning, moving around, if you will, with familiarity in this array of reasons. It's artificial, not in the sense that it's imagined. While it may in some sense be made, it's not just made up. It's a matter of practice, of craft, perhaps. First of all, it's a social practice, by which we mean it's the work of many hands involving actions oriented to other participants. And crucially, it's a discipline, that is, an activity governed by standards of performance. One can participate in this well or poorly, and a discipline that's learned through study and in part through what we might call habituation. So to participate in a social practice is to engage in conduct, mastering a discipline, learning a combination of dispositions and habits and skills. To learn how to participate in a social practice is to learn how to move around with relative ease in a common world. But law is a particular kind of social practice. In particular, it is institutionalized. It's modeled in courts, but practiced well beyond it through all aspects of social and public life. The exercise of its discipline is structured by sometimes complex hierarchy of institutions and roles and authorities. The habitat of this social practice, let me say something about that. Law is put to work in a territorially bounded community. The membership in this community is not strictly voluntary. It's heterogeneous and non-intimate. People in this community are engaged in complex networks of interaction. So this modus operandi, this attempt to give normative guidance, is directed to rational agents who comprise and interact in and as a public. So the normative guidance is addressed first to a public made up of these individual rational agents. But law, I said, law as artificial reason, is a discipline. Let me just mention some features of this discipline. First of all, and most obviously, it's discursive. That is, it is articulate and argumentative. Its activity consists of making publicly articulated arguments. To learn this discipline involves learning how to make one's way in this argumentative network together with others. The moves in this game are arguments, uttered, challenged, defended, revised. Because it is articulate and argumentative, this discipline is also reflective and self-critical. Critical assessment of claims made is the distinctive habit or skill of responsible participants in the practice. Secondly, it's collaborative. That is, individuals participate in a common practice. So legal reasoning is done, while it is done by individuals, is never done for their own part only. Rather, legal reasoning is oriented towards and offered as a contribution to the common reasoning of the community of participants in this practice. While each takes responsibility for his or her judgments and arguments, they seek consilience, convergence, if you will, of divergent and sometimes discrepant judgments that are that apparently are in some kind of discrepancy. Third, this law discipline is time-minded or time-mindful. Law discipline anchors deliberation and reasoning to the past, to recorded actions and decisions and articulated rules that are regarded as acts of the community and normative or binding on them and its representatives and officials. This articulated record is the visible, you might say, epidermal layer of law. But it doesn't dwell on or merely repeat the past. Legal reasoning is mindful of the trajectory of law from past, the community's past, into the community's future. I once said law is time mindful like a melody, where the initial tones of the melody bear in them the seeds of the remaining tones that fill out and give meaning to the whole. In this way, law not only has a history, a recorded existence in and through time, but more importantly, it orders time in and of the community. It orients practical deliberation to the cross-temporal life of the community. And lastly, although there's more to say about this, the dominant mode of reasoning is analogical and system or system-minded or systemic, all the while focusing on the pragmatic upshot of individual decisions made through this reasoning. So what I mean by this is that legal reasoning seeks patterns of similarity of decisions, actions, and reasoning, and evaluates them for their suitability, that is, their general coherence within the structure of reasons and norms of the law, and their, what we might call, workability on the ground of quotidian social life and interaction. Pressure towards systemic coherence is a matter, then, of not of intellectual tidiness, but of public practical intelligibility. So this conception of law provides our inquiry into the nature and viability of rule of law with a ready, if complex, toolbox. It suggests some broad outlines of an answer to the question how law can do its job of tempering power. Understood as a disciplined practice of public practical reasoning, law offers a potent instrument of accountability, a key feature of law's rule and its law's ability to rule. Judgment plays a very large role in this practice, but with judgment comes responsibility. Accountability to the materials of law and the standards of performance of the discipline of reasoning within it, and accountability to other participants in the discipline. No participant in the practice, regardless of its role in the institutional structure, is exempt from the demand for an accounting according to law in its discipline. This also suggests that such accountability must be structured, institutionalized, by constituting mechanisms and networks of accountability. And it seeks participation in these mechanisms, while predominantly the task of first responders, as I call them, people who, by virtue of position and power, bear the greatest responsibility. This participation must include the community as a whole. I call the fundamental ethos of underwriting the rule of law and its sovereignty fidelity, the ethos of holding those who exercise ruling power accountable to the law. And that's the responsibility of all members of the law-governed community. But we might ask, is law valuable solely for this largely instrumental reason? Perhaps not. A little reflection on law, conceived as artificial reason in this way, suggests that law, just by virtue of what it is, perhaps I should say, when it is working well, has some intrinsic value. One way to uncover this value is to think about perhaps fanciful proposals to replace legal intelligence with AI, computational intelligence, as the preferred technology for tempering power. Think about it that way. That is, some have suggested to replace the rule of law with the rule of algorithms, to put Chief Justice robots on the bench. Assuming, as seems reasonable, that computational intelligence is fundamentally different from legal intelligence, we might ask, so what? That is, what of any value is lost if we accept AI in the place of law? In a word, and put rather abstractly, what is lost is normativity. That is, a mode of governance and association that no longer engages the deliberational capacities of rational moral agents. Let me just spell that a little bit. What is lost? First of all, agency. What's lost is a form of governance that recognizes, respects, and fosters the moral agency of those it governs. AI mechanisms remove governing from the realm of deliberation, decision, and responsibility. It goads rather than guides. AI mechanisms manipulate rather than engage deliberation. They remove regulation from the deliberative domain of those who are regulated, and rather than addressing that deliberative domain, rather than addressing and engaging that deliberation, they remove regulation from our participation and our awareness. Eclipsing judgment and responsibility, AI regulation treats individuals as objects. The administration of things replaces governance of persons. Also, participation is lost. According individuals a meaningful role in law, especially when it makes costly demands on them, it self-respects their dignity and membership in a community of peers. AI-dominated settlement of civil disputes and AI-dominated enforcement of the criminal law provide no opportunity for meaningful participation in the governing process by those who are immediately affected or by the public at large. Third, what's lost is accountability. Now, AI partisans celebrate computational accountability, as they call it, but this offers only explanations of the mechanisms and its operation rather than justification of its output. Accounting in this case, accounting replaces accountability. Counting and calculation replaces the process of offering reasons and arguments. Moreover, such accountability as there is put in the hands of experts, so it can't function as a component in a network of mutual accountability that engages citizens and officials. Finally, law, when it meets rule of law standards, makes possible, but doesn't guarantee, but makes possible a valuable kind of community, one that can approximate the value of that I call membership. I won't spell that out now, it will take us too long. It provides resources for establishing and sustaining meaningful forms of social interaction and political recognition that binds the community over time. Law offers a public language and public institutions in which members can address disputes regarding the terms of their common life, and in so doing, take responsibility for their common life over time. All this would be lost if AI were to replace law as the dominant mode of social ordering. Not only would this be no gain, but it would be a significant loss of value. So that's a rough idea of how the history has led to the articulation of a conception of law, to maybe deploying it to understand what law contributes to the aim of the rule of law, which is to constrain and temper ruling power. However, this understanding of law and its relationship to the rule of law is pretty complex. It has lots of moving parts. Some of them seem to move in different, maybe even opposed directions. We must acknowledge that there are inevitable tensions, contrary movements within this understanding. I think we need not think of them as contradictions that threaten the coherence and stability or integrity of this understanding of law, but they must nevertheless be acknowledged and managed adequately. I call them inevitable but fruitful tensions. They're fruitful because they can add strength and depth to our understanding. Now, I recognize that there are several such tensions. I will mention here only three. First of all, what we might call law in the imperfect tense. We acknowledged earlier at the outset of our inquiry into the nature of law that while law may have an intrinsic value, it is not necessarily just or good. We must also recognize that laws do not necessarily meet standards of the rule of law. Laws can go wrong in many ways. The law in any polity is likely to be imperfect. Further, legal practice itself, law in any particular polity, may only imperfectly fit the model of a disciplined practice of public practical reasoning. For example, consider the alleged systemic or collaborative character of law's discipline. Any clear-eyed observer of familiar legal orders would report varying degrees of incoherence evident in them, and officials and judges who evidently pursue their own political or personal agendas, disregarding the requirement of an effort towards consilience of discrepant views. As descriptions of actual legal practice, the alleged systemic and collaborative dimensions seem fictional. However, these imperfections highlight the fact that law is a social practice, a discipline governed by performance standards. The account offered, the law's artificial reason, seeks to capture the practice as defined by its performance standards. The systemic coherence and serious efforts at collaboration mark generic performance standards of the discipline, not facts about the practice. We might call them regulative ideas that are implicit in the practice. Participants in the discipline may not meet its demands, but this would be a failure of the participants. They fall short of this regulative ideal, not a failure of the account of the discipline. Furthermore, entire legal orders may fall short of the regulative ideas of law's discipline. They would not thereby fail to be legal orders, but they would fall short of what we minimally expect of law. Second tension, fruitful tension, I believe. This is what I called the problem of congruence. Now, a problem arises immediately with our proposed understanding of the law. One of our bedrock observations was that law has a distinctive modus operandi, namely that it seeks to provide normative guidance to law subjects, capable of grasping reasons that are addressed to them as active members of a general public. Yet, law often presents itself as a vast complex of obscure rules that only the most dedicated student is likely to master. However, if this framework of reasons is largely inaccessible to those to whom they're addressed, or the reasons are practically unintelligible, they can't function as law, that is, as normative guides. And our favored conception of law seems to deepen this problem, since it puts heavy emphasis on the artificial nature of the practice and habituation. And that is not ready to hand for ordinary members of the community who have lots of other important things to do in their lives. The problem of congruence, of a gap between law and the quotidian lives and practical reasoning of law subjects, poses a challenge to our proposed understanding of law. It also poses a challenge to my proposed understanding of the rule of law. For at the heart of that ideal, as I've argued, is the necessary ethos of fidelity, a responsibility not only of first responders, but of the community as a whole. If law is largely inaccessible to them, they will not be able to get their accountability activities off the ground. There is then a twofold tension between law understood as essentially offering normative guidance to rational and moral agents, and the idea of law as artificial discipline of practical reasoning. and an effective technology by which ruling power can be tempered. So let me look at each challenge in turn. First of all, the challenge to the law is artificial reason. We must not deny that law can, and perhaps too often does, fail fully to bridge the gap between law's declarations and the public's uptake. Congruence is not a necessary condition of the existence of law, but rather a fundamental regulative ideal by which its performance is measured. Legal orders can fall short of this ideal, and we must be mindful of the causes or conditions of this falling short. But it does not necessarily fail, and shortfalls can be remedied. The inevitable gap can be more or less effectively bridged. Let's think a little bit about normative guidance and how the access of legal subjects to law can be mediated. Now, guidance may be direct via explicit directives, but also infrequently it's indirect. Law guides by giving normative significance to certain actions and activities, roles and relationships. It defines statuses and competences, accords to action meaning as claims against or responses to the actions of others. Constituting relations between employer and employee, or marriage partners, or municipal citizens. By doing so, law defines a horizon within which the deliberation can take place. In this way, law guides not by explicitly directing the behavior, but rather by providing an infrastructure or context for meaningful interaction. Law, when bound into the fabric of ordinary social life, can give reasonably effective guidance. Even if law is not within the immediate grasp of law subjects, it may be able effectively to guide if it's available on, we might say, an as-needed basis. This brings us to what seems crucial here, the fact that law can be mediated in specific cases where more detailed or precise grasp of norms is needed. It's often available by way of a variety of mediations. For example, lawyers are key intermediaries. They provide knowledge of specific areas of the law as this knowledge is needed. Law subjects may not have anything approximating a comprehensive grasp of the law, but may know enough of the basic categories and concepts to navigate successfully their daily activities and to know when they need to consult with more expert knowledge. Thus, professionalization of law's discipline is not necessarily a threat to law's project of providing normative guidance. Rather, it can play a crucial role in carrying out that project. The tension here then represents a kind of task rather than a challenge. Since the congruence demand expresses a regulative ideal, the task is to bridge the gap between law's artificial character and the quotidian lives and practical reasoning of ordinary law subjects. Thus, if law is to do its guidance job, we must pay attention to forces that widen the gap, to forces that alienate law subjects from the law, disabling law's efforts to provide normative guidance, and we must work to resist these forces and correct the influence on law. So now to the challenge to the rule of law. Fidelity, the tension here with fidelity defines a task for the rule of law. Defenders of the rule of law can't merely assume that sufficient understanding of law will be available for those responsible for accountability holding. So we must pay serious attention to building and sustaining institutions of government and of civil society to educate, mobilize, coordinate, and discipline the activities of individuals, thereby enabling them to organize themselves into effective collective bodies to hold power wielders to account under the law. Where these institutions do not exist, the rule of law will surely fail. Where they are weak or compromised, the rule of law will be threatened. where commitments of the people who are needed to make these institutions function properly are not nurtured, encouraged, and supported in their efforts, where the moral climate of the community fails to support or may even undermine their efforts, the rule of law, again, will falter. As the Indian Supreme Court Justice Kahana once wrote, 3 marks of decaying rule of law are a docile bar, a subservient judiciary, and a choked and coarsened conscience. The fidelity ethos is the animating spirit of the rule of law, as I've argued, but it can do its work only through institutions and organizations of the state and civil society that are defined and defended by the law. And it can only thrive if the moral climate of the community submits its core commitments. Thus, the congruence tension, while significant, can be fruitful because it lends motivation and structure to uncover gap widening or alienating forces and construct means for bridging that gap. It is also fruitful because it brings home and it is also fruitful because it brings home the fact that a truly philosophical jurisprudence must work in partnership with other modes of inquiry into the law. Here I return just briefly to the idea of law jurisprudence as a sociable enterprise. The philosophical jurisprudence looks for participation with specifically sociological inquiry into law's operation. For philosophical jurisprudence has to learn how law subjects come to learn the law, how they incorporate this inevitably partial understanding into their ordinary practical deliberations, and how the inevitable gap can be bridged. Philosophy cannot do that on its own. It must work in partnership with other modes of inquiry into the nature of law and the experience of law. One final tension. This one arises from a question I call the tension between universal and local. This tension arises from a jurisprudential question, a question of method and status of the understanding of law as artificial reason. You put the question in terms of a challenge. Law as artificial reason is proposed as an account of the nature of law, and subsequently, in answer to the question, how does or can law do the rule of law job of tempering power? However, this model of law was suggested, wasn't it, by a study of classical common law jurisprudence. That is, a local and thus historically and culturally limited account. How can it claim to be an account of law's nature that is an understanding of law wherever and whenever we find it? Philosophical jurisprudence, after all, aspires to universality, doesn't it? To transcend this local and contingent existence of law. And yet, this account seems blatantly to embrace the local. Embedded in this challenge is a legitimate concern. But I want to argue that the challenge rests on 2 mistakes. One regarding the nature of the philosophical enterprise, the other concerning the nature of philosophical jurisprudence. Let's take one up, take them in order. The enterprise of philosophical inquiry. The challenge assumes that a philosophical account of the nature of whatever phenomena it's inquiring into must be developed from a point of view that is entirely disengaged from any particular local perspective available to the inquirer. Bertrand Russell, for example, insisted that, quote, a certain emancipation from the slavery to time is essential to philosophical thought. The philosopher's aim on this view is to describe the world in itself, independent of local perspectives and the idiosyncrasies of inquirers. In Bernard Williams's words, it aspires to construct an absolute concept of the world. Now, we might wonder whether such an absolute concept of the world is achievable. But even if it were achievable, it would not be appropriate for the philosophical enterprise, I believe. For philosophy seeks an understanding of our common experience, and it seeks to make sense of our experience and lives to ourselves. Making sense to ourselves must take into account the kind of beings we are, with the kind of sensory and intellectual capacities that are natural to us, and the kind of lives we live. Williams reminds us that our understanding is inevitably historically situated. And if philosophy hopes to engage our understanding, it must be sensitive to the historical dimensions of our common lives. It must speak to us in the language of conceptions and modes of representation to which we have some access. If an absolute concept of our world were possible, its deliverances would be of little use to us. Actually, it would make little sense to us. Philosophical jurisprudence. Philosophical jurisprudence seeks to make sense of our experience of living under and within the province and practice of law. Three distinctive features of law decisively shape philosophical reflection on it. The social practice of law is reflective. It's reflexive, that is, in a sense, recursive, and it's intrinsically temporal. In virtue of these features, philosophical reflection on law must not detach itself from the local, contingent, and historical, but must engage it actively. Let me say just briefly a word or two about each of these elements: the reflective, the recursive, and the temporal. Legal practice calls for self-conscious and responsible judgment of those engaged in it. This is reflective. And this in turn requires a grasp on the nature of their actions, the circumstances of its performance, the rules designed to guide them. Competent participation in law's practice involves a reflective grasp of the standards and their interrelations. It's recursive in this sense. What participants are doing is determined in part by their understanding of what they're doing and why. And this understanding is public or common, constituting a kind of conceptual commons on which the individual participants draw for their particular understanding. In addition, some participants, those with the leisure and inclination and perhaps capacity to do so, reflect on and articulate these public meanings in general, more nearly theoretical accounts. Okay. Third, temporal. Law's reflective recursivity, if we want to call it that. Law's reflective recursivity also has a temporal dimension. Public reflective understanding of the practice arise in, respond to, and persist through social, political, and cultural circumstances at specific points in time. As those circumstances change over time, so too may the understandings of law change. Accompanying the practice of forms of law across much of its history, philosophical, or broadly theoretical, modes of reflection have sought to understand this practice, its structure, its purpose, its value, its limits, and its relations to other fundamental features of human social life. The history of law involves the history of such theoretical understandings of law. The lesson to draw from this is not the banal thought that conceptions of law must be understood in their historical circumstances, nor the shallow historicist skepticism of broadly philosophical inquiry that insists that legal philosophy be replaced with strictly historical inquiry. The lesson, rather, is that a truly philosophical jurisprudence must not only be mindful of the history of law and its theoretical reflection on it, but must engage philosophically with it. However, herein lies the tension. If our philosophical sense-making is too wedded to the local, too dependent on our immediate and unreflective thoughts, intuitions, practices, it will be enslaved to our ignorance and myopia. Philosophy, I believe and insist, is constitutionally critical. A critical part of its remit, of its claim to our attention and energy, is to destabilize comfortable stabilities of thought due to ignorance, indolence, myopia, and insufficient self-awareness, or due to past victories, not of argument, but of politics, power, or prejudice. Thus, philosophy is, in its constitutive regulative idea, philosophy is critical, not only of deliverances of the phenomena it explores, but in equal measure critical of its own presuppositions and performance. Criticism requires some conceptual, intellectually achievable distance. Where is this distance to be found, if not in a fully universal, utterly detached perspective on human experience? The answer, I believe, lies in the very historically situated nature of human experience and systematic thought about it. Philosophical jurisprudence needs critical distance and resources for critical assessment of our current understandings of familiar practice. A grasp of the forces that have shaped the practice and the presuppositions shaping and the presumptions shaping it provides the distance and resources needed for the task. It can help us break the tyranny of present intuitions shaped by preconceptions at or behind the horizons of our ordinary vision. And it can help us excavate, identify, articulate, and critically explore them, locating familiar notions in institutionally unfamiliar conceptual historical neighborhoods often sheds new light on those notions, revealing aspects or links to other notions and problems that we otherwise would overlook. Philosophical jurisprudence must engage philosophically, that is critically, the history of reflective understandings of law. In so doing, we are enabled, in Waldron's words, to grasp conceptions of law and controversies other than our own conceptions and controversies, and thereby understand better our own questions and answers. But more importantly, we're enabled to see how those conceptions and controversies, those questions and answers, related to social and political circumstances of their time and place, and to philosophical frameworks to understand them and appreciate them, how they might have influenced or decisively failed to influence our own practice. We may also learn an important lesson. To reverse the commonplace, the more things change, the more they stay the same, we might say, the more things stay the same, the more they may change. That is, while a concept might retain its place in our understanding of law over a long period, its content may have substantially changed, such that the phenomena it once captured or aspired, or the aspiration it once expressed, are obscured. Uncovering that change can enrich our understanding by loosening the tight boundaries of our familiar contemporary use. So the question regarding my proposed understanding of law as artificial reason is not whether it meets the standards of some universal time and perspective independent inquiry, but rather whether it offers an articulate, critical understanding that illuminates our experience of law, capturing what law does and what we do with it, an achievement despite its inevitable shortfalls, and whether it does so in a way that escapes, or at least doesn't prevent escape, the narrow confines of my or your or our cultural horizons. I believe it does, but whether it does so successfully remains to be seen. So let me say a few words in conclusion. A savvy high school teacher once put the following sign under the classroom clock: "Time will pass. Will you?" I wonder whether my 30-year-old self looking through my study window thinks this life's product of work passes. If that young self submitted it to ruthless mathematics of retrospectivism, does it add up? We might wonder. Or maybe, rather, what does it add up to? Does this philosophical symphony have an adequate, satisfactory ending? I guess I'm not the one ultimately to say. That's for further generations, for you to judge. I'm content to know that it is about the best I could have done. I want to end, this is unlike any philosophical lecture ever given. Nevertheless, I want to end with a poem, perhaps my favorite poem by the poet Merwin. It's entitled To the Book. It goes like this. Go on then in your own time. This is as far as I will take you. I'm leaving your words with you as though they had been yours all the time. Of course, you're not finished. How can you be finished? Even the words are not finished, though they may claim to be. Never mind. I will not be listening when they say how you should be different in some way. You'll be able to tell them that the fault was all mine, whoever I was when I made you up. Thank you very much for your attention.
Thank you, Professor. Thank you for that. It was illuminating. Those were powerful, touching words indeed. Necessary words. I would like to congratulate you on your talk, but most of all, I would like to thank you so very much for it. Time didn't pass; it flew by, and I guess we are all uplifted by the end of this talk. So before I will give it back to Gilberto for his comments and questions. I would just like to ask Professor permission for addressing the audience in Portuguese for a bit.
Yep.
Just some friends and colleagues that I would like to acknowledge. Eu quero agradecer aqui a presença do coordenador do nosso programa de pós-graduação em Direito, professor Anísio, que nos acompanha. Quero agradecer também publicamente a parceria dos amigos e queridos colegas Cláudio Arimelo, Bernardo Teixeira e Ziel Lopes, que também nos acompanham aqui hoje e que dividiram conosco as atividades do grupo nesse semestre. Sem eles, essa atividade de hoje também não teria sido possível. O meu agradecimento público a eles. E também ao colega Pedro Adame, que nos acompanha, e outros amigos que vêm mandando mensagens aqui. Então, obrigado pelo prestígio, pela audiência. So, enough with that. Gilberto, eu acho que eu cometi a grosseria de não te apresentar extensivamente antes, mas considere isso não como uma diminuição, e sim porque tu és já um membro da casa aqui, tá? Então, a tua reputação antecede, vamos perder menos tempo com o teu vasto currículo e mais com as boas coisas que tu tens a dizer. So, Gilberto, you have the floor now.
So, Professor Balsama, thank you very much once again for accepting one more of my invitations. 30 years of age. I am now myself 30 years old. And just briefly, in Portuguese again, because I need to talk to the staff. Meninas, acho que pode deixar os três, porque agora é a hora dos debates, então não é uma fala, é Isso, obrigado. Well, I was just mentioning that we could be all the three of us on the stage now. I am now myself, Professor, 30 years old myself, and I am very much honored to be a follower of Postinian jurisprudence. I have to confess to you that my students have a running joke that every time I start a lecture or a class or anything like that, they start their stopwatches and they see how long will it take for me to mention your work. And at first I was a bit embarrassed by that, but now I'm happy that this is the case, because while I was listening to your talk and every time I read your works, I find it very difficult for me to find something that I am in disagreement with. And I have spent almost a year in Cambridge discussing with Matthew Kramer and trying to convince him that you were actually right. And I don't think I was successful in that. I don't think I have managed to convince Matt, but I left Cambridge all the more convinced that indeed you were right. And again, I have no points to challenge you or any objections, but I have some questions that I would perhaps be glad if you could clarify, because that would then refine my own convictions about your work, because that's exactly what I'm trying to do now. I'm trying to follow in your footsteps. I always mention to my students that instead of reading what I have to say, they should read your works first, because everything that I have to say that is right, you have said better and more eloquently before I did. But well, again, there is something, one tiny little thing that I hope is very tiny, that still leaves me a bit puzzled in your talk and in your writing, and that is when you mention law that fails to meet rule of law demands. I have mentioned Matt not only because of a personal note, but because you have recently engaged in a debate with Matthew Kramer, and contra Matt, you have defended that there is not such a gap as he claims between law's very existence and law's rule, and that this gap might perhaps be filled by normative guidance. At the same time, however, you still mention the possibility of law that fails to meet rule of law demands. That is still law. However, doesn't law conceived as artificial reason allow us to say that there is something wrong, legally wrong, maybe conceptually wrong, with law that fails to meet rule of law demands? Because after all, not only intrinsic value, law, as you yourself say, has its own modus operandi. So maybe isn't law that fail to meet rule of law demands a corruption of law itself as a distinctive practice that it claims to be? So maybe in Hartian terms, against Hart himself, maybe law that meets rule of law demands would be the central cases of law, and law that fails to meet rule of law demands would be the limit cases of law. Because after all, I believe it is correct to say that law itself as a practice, as a distinctive practice, has maybe an intrinsic aspiration to legality, an intrinsic aspiration to the demands of law's rule, as you articulate in law's rule, and as you, after all, articulate at the end of the day with the very idea of law as artificial reason. So while I am fully in agreement with everything you say, I am still not sure how I feel about this idea of law that fails to meet rule of law demands. That is still law. So if you could maybe comment a little bit on that, please.
Yeah. I gestured towards a response to this when I talked about the fruitful tension I identified as law in the imperfect tense. When I was thinking about the rule of law, that ideal, I wanted to be sure that we didn't think that we could just get all the substance of the ideal out of what's sometimes called the concept of law itself. Rather, I wanted to look at the ideal of rule of law as itself a moral political ideal that draws upon law as, if you will, the technology by which its fundamental aim, that is tempering ruling power, is achieved or worked at. But that does throw us back. And so I wanted to know whether there was something about law itself. Now, it turns out that as a social practice, it's not something that we can understand by looking at it, as it were, entirely from the outside. The Hartian idea of an internal point of view was a useful start on this idea. But to look at law from the internal point of view is not to look at law at the beliefs of people who are committed to it. It's to participate in that practice. Why? Because through understanding that practice, we grasp the standards of performance. And in this case, the standards of performance are performance of law, not as justice, not as decency, but as law. So you can engage in that practice more or less well. You can fail. And it can turn out that whole manifestations of this practice can fail to meet certain key dominant features of law as a social practice. That is, the idea of law is inescapably normative. Not only normative in the sense that laws are normative, but law itself has its own internal standards. Now, the question is, and so we can talk about legality here. What I want to be clear about, and I think it's really important when we start thinking about the rule of law, is that you might want to say, I want to avoid those who want to say, but if the standards are not maximally met, then we don't have law at all. And that puts us in a peculiar position of denying what seems to be a palpable fact for all of us, especially for those who are, if you will, victims of law's failure. We need to take the view of, now, let me put it differently. It must be possible for laws to exist and be bad, not only unjust, but bad with respect to the very regulative ideas of law. So there is a sense in which the existence of law is one thing, and the validity, we might say, the meeting the standards of law is another. But the existence of law is better or worse according to those standards of legality, not standards of justice. So there is a tension here, I understand. And the tension is understanding the fact of this social practice, and yet a practice that is normative, both in its modus operandi and in its very nature. I mean, it's like the practice of plumbing, right? Plumbing can go bad. Why? Because sometimes the very rules that you need to follow in order to be a good plumber are just not followed. Or electrician. I have a whole house that I renovated some 10, 15 years ago, in which the electricians failed the norms of their practice. And we're living with the result of them. They didn't fail to engage in plumbing. They failed to do the job of plumbing well, right? The job of plumbing. We can talk about the job of law then, all right? So that's roughly the way I want to approach it. I don't want to deny that there's this tension. I want to say it's a tension embedded in the very idea we've got of law, not unlike many other social practices. Thank you. Yeah.
Thank you, Professor. Chico, would you like to bring up one of your questions? Should I follow up? How do you feel?
Can I bring one of mine and then I'll give it back to you?
Absolutely.
So I'm sure there's a follow-up to that, but but I don't want to miss the opportunity to jump in. So, Professor, I would like to address a question about some of the ideas advanced in your 2022 book, Law's Rule. In Law's Rule, you vigorously advanced the proposal that, at its core, I quote, "the rule of law promises protection and recourse against the arbitrary exercise of power using the distinctive tools of the law," end quote. So the, quote, "organizing aim of the rule of law is to temper the exercise of power to avoid, to the extent feasible, its arbitrary exercise," end quote. And it, quote again, "chooses law as the means of doing so," end quote. So following that, you argued that three basic principles follow from this core idea of the rule of law, which are sovereignty of law, equality in the eyes of law, and fidelity. My question focuses on fidelity.
Yeah.
Fidelity, as you say, requires that all of its members, and not merely the legal or ruling elite take responsibility for holding each other, and especially laws officials, accountable under the law. I would like to hear you say a little more about fidelity vis-a-vis one of the challenges you address in chapter 12 of your book, which deals with crisis and pardon, with the executive power leashed. You portray the challenge of discretionary judgment as a challenge mostly to the principles of reflexivity, meaning that the law by which rulers govern must also govern the rulers, and exclusivity, meaning that all ruling power must be legally ordained. But I wonder if it is not an even bigger challenge in the face of fidelity. In the following sense, whenever a constitutional system grants a broad or even unlimited pardon power to any of the political branches, whatever its face may be, call it executive pardon, call it amnesty, how can one keep a rule-abiding citizen on board? To put it differently, how would the fidelity ethos remain in place when you allow for the opportunity of law being disconsidered in the public sphere?
Wonderful question. And I thought about this, the way you formulated the question at the end, with respect to a number of different challenges or threats to the rule of law. I hadn't thought of it with respect to pardon or crisis, but the idea is the issue will be this similar. Fidelity is I understand it to be a commitment. I call it an ethos, but a commitment that individuals undertake, but they often undertake them and have to undertake them in some kind of collective body. But it's a commitment and a responsibility to hold those who wield ruling power accountable to the law. That commitment is vulnerable, right? It's vulnerable to a number of different factors, or rather, we can put it differently. Its health depends on there being a number of different conditions met in place. One of those conditions is that there is a general moral climate that supports and encourages that commitment, that upholds people who exercise that responsibility, that challenges those who fail. If the moral climate is weakened, the fidelity commitment will be weakened. And so that crucial part of the rule of law. So it's you've focused on a really important part of the idea of the rule of law, and that is it's not just rules. It's not just institutions. It's the people who participate in that, who are part of that institution, and those who are governed by it. Right. However, another important condition is that those who are bound by the law in various ways stick to it, and in many and are not allowed to get around it, that are not allowed to ignore it, to treat it with contempt. The failure to follow those rules is a failure, and if a failure to follow those rules with impunity, that is, without adequate response, accountability holding, where the violations and the contempt are not met with demands opposing it from what I call first responders, but also from the community. If it doesn't do that, it fails. The problem, however, is that when that, so that's a failure of reflexivity. But there's a failure also of fidelity, and this is the concern you raised. And I appreciate it fully. And that is when it looks like those who are in positions of power, especially those who are in elevated positions of power, let me not talk about our president, when they act with contempt for the rule of law, for the laws that govern them, and there is not sufficient pushback, accountability holding, then those who are in the ordinary, in the position of ordinary citizens are going to say, look, he can do it, why not me? Why? Fidelity is costly. It costs time, energy, attention, and sometimes puts one's own life in certain respect on at risk. Why should I risk it? He does it, gets away with it. Why can't I? Now, why can't I not, on the one hand, put all that energy into holding accountable? The other is, why do I care about the law's constraint on me or on my neighbors? If the law is, in this respect, so capable, so weak, or the forces that hold people to the law are so weak or are compromised, then those who are, as it were, not officially engaged are going to say, so what? I don't care. There's a kind of risk of alienation, an alienation from the very activity that upholds the rule of law, that can undermine it. So your point is absolutely right. How about pardons? Well, if the pardons appear to be and cannot be understood otherwise than serving personal, political, or self-oriented concerns, if they can't even be given a public representation as in somehow serving the public good, then we've got a real challenge to reflexivity, but also a challenge to fidelity. When I argue for, I mean, the problem in the American Constitution is that, according to many, the understanding is pardon power is entirely a matter of the executive power, not constrained by law at all. It's lawful, it's legal lawlessness. Has no laws because there are no standards. It's legal because it's authorized by the Constitution. That's a fundamental violation of the rule of law. Law must not only authorize, it must provide standards. So we must have, I think the Constitution just goes wrongs here, or at least those who understand it as such. If our Constitution is to support the rule of law, is to serve the rule of law, it must embed at all points along the way standards by which the behavior authorized can be assessed, and institutions by which that can be judged. So yeah, fidelity is a problem there too.
Thank you so very much, Professor. This was exactly what I was hoping to find in your answer. Gilberto?
Well, if I may, I'm going to go back to a more boring question. You can see very clearly here that I am the legal philosopher and Francisco is the constitutional scholar, because his questions are more pressing than mine. But I do wonder, Professor, you have mentioned some, well, we go back and forth. I mean, I'm certain Francisco will have more questions that are more concrete than mine, but it is indeed a curiosity of mine, because you mentioned some tensions between these ideas of yours, and Francisco just very well mentioned very clear manifestation of one of these tensions within this idea of law's rule. But at first, at the outset of your talk, you mentioned different stages and different phases in your intellectual journey, your intellectual career. And it seems to me that there has always been a unifying thread between these works, and that could perhaps be normative guidance, or you can rephrase it as you prefer. But my question is, from your early work on, well, Bentham and the common law and the common lawyers, and your transition to conventions more clearly, and then your approach to normative guidance more specifically against heart and norms, reasons, and the law. Now laws rule, and the more clearly articulated version of law is artificial reason. I was wondering if there are some tensions within your own work, some shift perhaps, or some postuma, first postuma and second postuma, early postuma, later postuma. I'm not sure if one can say so, because I can see very clearly that there is some sort of unifying thread, but I don't think at the same time that the postuma that I read in conventions is exactly the same postuma that I read today in artificial reason. So if you can maybe please elaborate on that.
Sure. Actually, it's comforting that there is a difference, this discernible difference, because that suggests that on one reading, I matured. I intellectually matured. Take this talk about conventions, okay? As you can see, conventions are just connected to the idea of social practice and how social practices give reasons, and then there's a lot of work developing that idea and so on throughout the work I've done since the 1980s. The notion of convention, I tried to do two things in that very early piece. The one is to understand what Hart could mean by law, and in particular, the rule of recognition as a social rule that has some kind of normative force that could be discovered by looking at the practice. Okay, and how does that work? And it's got to be something that's not just a matter of the individual's commitment to it. It has something to do with reasons, and can't be a matter of justice or goodness or whatever else, because he's a positivist. So I looked at the idea of convention as a way of articulating the notion of a social rule, which was at the heart of Hart. And for that purpose, at the time, what was most available to me was a game theoretic understanding of it, with a little bit of influence from, I have to admit, Lon Fuller and the idea of implicit law. So I took the conceptual framework of David Lewis type conventions as a way of trying to articulate that. As time went on, I began to realize that was really, in a way, too narrow an understanding of convention, too narrow understanding of what then I began to call custom. And it especially, oddly enough, in my thinking about customary international law, I began to think more about how social rules could be understood, not as David Lewis type conventions, but as something deeper and richer. And so what emerged is this idea of social practices that have standards internal to them. I confess there was a certain amount of influence there of Fuller, but also, oddly enough, of a philosopher, Robert Brandom. So it emerged from that much more technical kind of thing to something that was richer, more open, more, richer. And that over time then played a role in my understanding how law itself could be understood as a social practice. Of course, it was aided by reflecting on Dworkin, a lot of Dworkin's work, and how that his interpretive account was helpful in some respects, but not either quite right on. So as things matured, I moved away from David Lewis through Dworkin, Fuller, to something that looked a little bit more like myself. And here, oddly enough, my reflection on 17th century English common law played a role.
Thank you, Professor. Thank you very much. That's very clarifying.
I too have a conceptual question for you, but I will leave it to the end, only if we have an extra time, because I would love to drag you back to constitutional theory and thinking.
Yep.
One question that have been puzzling both Gilberto and I over time is to what extent can we really rely on the objective authority of law to control political power and political processes? So one of the focal points of my research group over time has been the challenges faced by constitutional democracies and the question of how far can law actually go to prevent democracies from backsliding and so forth. So law's rule gave us some new tools and a fresh perspective to address this issue. And with that in mind, I would like to ask a question about norm saboteurs, the thread discussed in the course of chapter 8 of your book. You yourself ask, quote, how is a defender to respond to the saboteur's challenge, end quote. And your answer is basically against playing reactive hardball or playing the saboteur's game. So I take it that you're also against the militant democracy approach. I totally agree that retaliation is more likely to further erode constitutional norms and weaken public trust in the ability of governmental institutions to live up to its underlying values, as you put it in your book. But is it ever the case that law's rule must concede to preserve a different set of principles of political morality, such as democracy, justice, peace, or human rights? Can it ever be the case that the rule of law should be put aside in order to prevent, in the public domain, I mean, in the public sphere, in order to prevent, for instance, democracy or human rights from eroding? I'm not sure if that's clear.
Wonderful question. Very important question. There are two sides to the question, I think. There are two sides to an answer to the question. One side is we might call quasi-theoretical, and that is, how does the value and importance of the rule of law relate to other critical values of political morality, democracy, human rights, and so on? How does it stand in that constellation? What's its place in that constellation? And how do we manage its relations? The other is strategic. If we have an understanding of the relationship, how do we follow out that with actual strategic actions? Okay. I'm not very good at strategy. I'm rather politically naive when it comes to those things. I like to rely on other people. My wife's very good at that, by the way. But let me talk about the first side and then get to the strategic one. Notice that tension was in play in that paper you referred to, named Constitutional Norms, where I talked about how to deal with deep worries about the integrity of the court system as it in the United States as it now exists, how we respond to that. Those two sides played out there. On the theoretical side, if you want to call it that, I'm very mindful that the rule of law as a value of political morality is one amongst others. And it is, while it is terribly important, it is not, shall we say, totalitarian. It doesn't overrule every other value every time there's a conflict. Those values can then come into conflict, and it takes real careful responsible, mature judgment to decide when we must follow the dictates of the rule of law despite its cost, and when we must follow the dictates of some other competing moral value. Justice, for example. If the laws go wrong, badly wrong in terms of justice, then we may face a situation in which, in order to change those laws in the direction of justice, we must do something that's inconsistent with the demands of the rule of law. I understand that as a theoretical proposition. I'm very worried about articulating that in the public domain because it can be exploited in ways that we wouldn't want. Nevertheless, that's what we have to keep in mind. Now, one further thing needs to be said, in that it is my view, and I would like to argue this at length, that the rule of law, while it is one value amongst others, it plays a really crucial role in a kind of interdependency with some of these other crucial moral values. For example, democracy. Democracy and the rule of law are not simply opposed, they're interdependent, so that democracy really can't get off the ground and can't maintain itself without there being an infrastructure of law that meets the demands of the rule of law. In that respect, democracy depends on the rule of law, not utterly, but very heavily. The same thing, it seems to me, goes for justice, because one of the important features of justice is not merely a question of what the sort of state of affairs is, whether it meets conditions of justice, but how it's achieved and maintained. And the way in which it's achieved and maintained will bring into play both the rule of law and democracy. Justice imposed from the top against the will of any and everyone, and without means of holding those structures of justice accountable to law, is inconsistent with justice, in my view. So that we've got a deeper interdependency between these various views. Nevertheless, I'm willing to believe that in certain circumstances, one must, as a moral agent and committed to the deep principles of justice and decency and democracy in a political domain, in one's own political domain, there are times when I must commit civil disobedience, not just what I call civil dissent. That is, act in a way that's against the law. Sometimes that's necessary. Now, the sometimes is a weasel word, because now we get to the strategic part of it, right? How do we manage that? And the question here, the one of the important features of the paper on constitutional norms is that when we undertake these actions, which are, we might want to say, contra to the demands of the rule of law, contra to the existing norms in response to saboteurs, is that our aim is not to set ourselves up as another one of those saboteurs. Let me give an example. Currently, what's going on in the American political system is that Texas is trying to redistrict so that it will create a larger pool of Republicans to function in the Congress. The aim there is not to enrich democracy. The aim there is to install permanently a certain political party. What response can we have? Well, install it from the Democrat or the left side to install enough others. In a way, I mean, that's the kind of responsive things. But you have to keep in mind that in terms of democracy, what we're trying to do is to resist authoritarian and efforts to center the power and to make it unshakable. Our aim has to be to maintain democracy. So any strategic decision has to be kept. You have to keep in mind that the aim must always be, can we see through this effort of violating sort of the typical norms of democracy or rule of law, can it in the long term serve, or does it add to the erosion of the rule of law or a democracy? That's a terribly important question that we theorists can weigh in on, but we need strategists. We need to know how these things work out. And one thing that we know, this gets back to your fidelity point, one thing that we know is that when people in power act in a way that's inconsistent with what look like fundamental values, that encourages a similar kind of view from others, on the part of others. That kind of encouragement of dismissing the legal framework, that kind of influence is unavoidable. So our strategy has to take that into account. I wish I were better at that. I don't know right now. Well, that's enough. I wish I were better at that, but that's where our answers must come from.
Thank you very much, Professor. Gilberto, I'll give it back to you for your final question, because we are almost running out of time.
Yeah, I think that connects very much so to Professor Postma's last point, because as a final question, I think it would be more important than just asking for Professor Postma's final remarks. I wanted to see, because Professor Postma ends Law's Rule saying that this is not a book on conclusions, but an ongoing project, right? So I was wondering what's next for Professor Gerald Postma. I mean, I can see a very clear work on artificial reason as such, but what are you currently working on, and how do you envisage your next steps?
Yeah, thank you, Gilberto. I'm not sure what the answer to that is. I'm at the middle of my 70s. I'm not sure I want to undertake a vast new research project. What I'm inclined to do is to continue to talk about law's rule of law, and respond to particular kinds of problems that might arise. But in some sense, I feel I've shot my wad. I put it all out there as best I can, and I'm hoping that folks like you and others will carry the ball forward. So I have no specific plans for further research into areas. I realize that almost everything I say needs further argument, needs further development. The challenge of AI is enormous, serious, and I also understand that understanding and responding to it is extraordinarily complex. So I don't, mainly what I'm going to do in the context of philosophical jurisprudence is to, on the law's rule side, elaborate in various ways certain features of the book. On the general law's artificial reason side, I think what I will probably want to do is to organize a short book in which I expand a bit on those two important articles, because they provide a kind of template, which will then allow me to introduce various things I've talked about over the years. It will be more retrospective than absolutely new work.
You can certainly count on us for following on our footsteps. You can certainly count on that.
Good.
Do we still have time for one more question?
Of course. I'm happy.
Oh, so I have So I have a conceptual one that Gilberto and I discussed beforehand. Professor, in law's rule, you engage in a search for the grounding value of the rule of law ideal in order to uncover the values that provide it focus and force. And you eventually find it in the value of membership. Membership puts individual dignity, equality, and freedom from subordination to the will of another in close, internal, mutually qualifying connections, you say. I took from it that you have wanted to emphasize a relational perspective between people integrated in the relevant political community. So the social character of the ideal. And you actually compared this idea with the notion of friendship to capture a, quote, certain kind of community, one in which members are bound by history, interdependency, and a deep-rooted mutual regard that respects the distinctive features of each member and their ability to contribute to the whole, end quote. So I would like to hear you say a little more about this question. Why isn't human dignity a strong enough moral foundation? After all, it is also a mode of regard, a socially recognized position. To put it differently, in other words, what do we actually achieve when we ground dignity, equality, and freedom from subordination under this particular normative roof?
Wonderful question. Thank you for that. One of the things, a major objective of moving to the notion of membership was to find, to think of the rule of law's value as not in itself constituted. It rests on something more fundamental. So the question is, what value or values might do the job of supporting what we take to be most important, most valuable, most demanding of the rule of law? So it needs to take all the various aspects of it into account and try to explain why that's important, why each things are important. My thought, and one of the things that law does and focus on, as I understand law, especially law as a discipline practice of practical reasoning, what I understand is that it's not a set of law is not a set of rules addressed to individuals. It's addressed to individuals that find themselves in communities, in a public. Now, a public that's fractious and conflicted and all that, but a public nevertheless. And I wondered how the rule of law could be understood not simply as constraints on rulers, but as a way of making possible this kind of social interaction that itself is perhaps valuable. I call it a mode of, not only a mode of governance, but a mode of association. Law provides that, and the rule of law kind of shapes that. Well, how do you capture that? Dignity has to be a crucial part of it, but we can understand respecting the dignity of persons strictly in terms of understanding the dignity of this or that or other individuals, without paying sufficient attention to how that dignity gets supported, recognized, regarded in a community. And so the dignity aspect, or for that matter, the equality aspect, is, as you say, extremely importantly seen as relational. That is, the dignity gets it's within that relational context that dignity is best respected. It's not a matter of one-off either incidents or one-off movement towards one individual. It has to do with the framework within which human individuals live, interact, and the like. Okay, so it seemed to me that we needed something other than let me put it differently first, other than liberty understood as freedom of choice. Because freedom here has a different, more relational character. Equality has to be understood in a different sense than simply how much I get relatively to how much you get. It has to do more with where we stand, how we stand with respect to each other. That's why I talk about equality as a matter of peerhood rather than equality as a matter of how much we each have. That being so, dignity also plays that crucial role. Its dignity is part of this peerhood, I think. And so if we're really going to understand the way in which law, and especially rule of law, all its various features, can be rooted in something different, something more fundamental, it's got to be something that brings together dignity, equality, freedom, because we're talking about being protected against arbitrary exercise of power, all those things, in some kind of coherent package. And that's, I suggest, is this notion of membership. Dignity is not ignored. Dignity is located in that conception. And I think located more as freedom is located, or liberty is located more richly in this associational kind of picture. It's not surprising that this notion of mine is not mine. I found it, and it was influenced by understanding, deeply digging into early modern political philosophy. That's where it came from. It didn't come up out of my like a mushroom popping up after a good rain. So that's why I think, and I understand that membership is not in the vocabulary of most political philosophers. That's okay. They got to change the vocabulary, expand it, in my view, or tell me why it should stay where it is. Okay. Thanks. Thank you. Thank you very much.
Thank you very much, Professor.
To the risk of sounding self-congratulatory, I was thinking that we must have done something right in order to have the true privilege to have spent this morning with you today. So I thank you very, very much for it. My palms were sweaty. I guess you know that you're kind of an idol for us here. So that study constitutional theory, legal theory, and so on. So we are truly privileged to have spent this morning with you today. So I'll just give it back to Gilberto to say his goodbyes.
Yeah, I just wanted to thank you very, very much indeed, Professor. Like Francisco said, you're a personal hero of ours, and it is always a pleasure and a privilege and an honor to get to talk to you. Thank you very much indeed for your time.
Yeah, let me just say in response, you're very, very gracious, and it has been a pleasure to participate in this. I do think, partly in response to Gilberto's question, that I regard these activities, these interactions, as a kind of passing of baton. There is a race to be run, and I've run a good bit of it, and I'm not going to stop, but I do think it's about time for the baton to be passed. And so I'm grateful that you have undertaken to do that. I must emphasize, however, that if you are thinking of this as a baton of philosophical jurisprudence, it must be critical. That is, anything you take up from what I have tried to say must be taken up in the spirit of deep critical understanding of it. And I mean objecting to it, challenging it, finding new ways of I will have failed if you simply take the ball and run without this critical component. Thanks a lot.
Thank you, Professor. You can count
very much indeed. Indeed.
Have a nice day. Have a good day. Muito obrigado a todos por terem comparecido e nos prestigiado até aqui. Muito bom dia a todos. Goodbye, Professor. Have a good day. Thank you very much.
Thank you very, very much. Bye-bye.
Bye-bye.